SJC-11405, Frank J. Babbin et al., the Energy Facilities Siting Board, SJC-11406, and SJC-11407, City of Brockton, v. Energy Facilities Siting Board.
Thank you, Frank.
All right, let's proceed.
Good morning, and may it please the court, I'm Lisa Goodhart. I represent the 17 appellate residents of the City of Brockton and the town of West Bridgewater. I want to begin by thanking the court by allowing us to have 10 additional minutes for the argument of these cases. And with the time that I have, I would like to focus on the Siting Board's determination that Brockton Power's plans to build a new power plant in a densely populated, low-income community of color is consistent with the Commonwealth's environmental justice policy. And I'd like to make 3 points about that environmental justice policy argument. First, I'd like to say a word about the core premise of that policy and why it matters for this proceeding. According to the policy, environmental justice is based on the principle that all people have a right to be protected from environmental pollution and to live in and enjoy a clean and healthful environment. Significantly, the policy says explicitly that environmental justice is the equal protection and meaningful involvement of all people with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies, and the equitable distribution of environmental benefits.
But isn't this policy really directed to the process to ensure that the process is inclusive? Isn't it process-oriented as opposed to result?
I think the policy on its face has a lot to do with process, but it also explicitly has to do with more than process. And it's very clear from the plain terms of the policy that it's not just about the procedural things that ought to be done to encourage meaningful participation. And no one here is taking any issue with the Siting Board's affording of the appropriate notice and enhanced outreach and translation of notices into multiple languages, but the policy requires more. And it
doesn't create any rights.
It doesn't create a private right of action for the residents or for anyone else, Justice Cordy. But what does create a right here is the combination of the statutory right to judicial review of the Siting Board's determination and the statutory standard that the Siting Board is required to apply in making its decision.
But with respect to the latter, and you're referring to the clause in 69J and a quarter something.
Yes.
One of those clauses. If I understand it correctly, MEPA says, yes, you need to do more, power company, if the air quality triggers the environmental impact review. But Secretary Bowles said this one didn't. So on the once you have that, where do you go with respect to the environmental justice policy?
Where you go is to the individual agency making the particular adjudicatory determination, and you look at that agency's mission, and that agency must apply the policy.
Right, but the mission in 69J and a quarter says you have to do this consistent with the Commonwealth's environmental, et cetera, policy.
Yes.
So I would think that gets you back to both the procedural aspects of the environmental justice policy and, insofar as substance is involved, back to where Secretary Bowles says you don't need to worry about it in this case.
And I disagree respectfully, Justice Botsford. MEPA, the MEPA statute is all about procedure, and the MEPA statute doesn't aim to get at any particular substantive result. It is entirely aimed at ensuring that there is robust input and information and a process. And if the environmental justice policy were satisfied with that MEPA determination, then the policy would have been written only to apply to the MEPA office. But quite to the contrary, the policy describes what must happen under MEPA and then goes on to say that all of the agencies under the Secretary of the Environment, and now, based on the acts of 2007, the combined secretariat that includes energy and the Energy Facility Sightings Board, must have their own strategies and must make environmental justice an integral part of their operations. And the policy is written to make clear that each agency must do an independent environmental justice analysis, and certainly the Siting Board was free to look to that MEPA determination and to give it such weight as it thought appropriate, but it was...
But how should that get, I think I understand your argument, but how does it get executed in the circumstances of this case? If it's a dump site, it might be a little easier to identify. Do we look on a statewide basis or on a regional basis to see that the location, the siting of these kinds of plants are equally distributed in certain racially impacted areas, or as they are with non-racially impacted areas? Or do we look for the effluent that comes from these plants?
I think you have to begin with the analysis of the existing disparate impacts as a result of the historical discrimination, and Brockton Power should have been required to present to the board for the board's analysis a detailed explanation of whether and how its facility would be consistent with the goals of ameliorating that disparate impact and not contributing to an even greater unequal burden on the citizens of Brockton. So that should have been part of the analysis, and if you look at the Siting Board's decision, there are 3 lonely paragraphs in the decision that comprise the entirety of the environmental justice analysis. They involve no mention of the location of the facility, no mention, much less any meaningful analysis of what the burdens are and will be from the facility. And although the agency has great discretion and latitude in what it does, it is not allowed to punt entirely and ignore the analysis that must be made in order to make the critical conclusion that the plans are consistent with the environmental justice policy. It cannot be done without grappling with the health impacts that are already faced by this overburdened community, and Brockton is the 9th most environmentally overburdened community in the Commonwealth. And I see that I am out of time. I would commend to the justices the 2005 report by Faber and Krieg, which is in the record, not in our record appendix, but it is attached to the amicus brief of the Lawyers Committee for Civil Rights as an addendum. I would commend that to you, as well as the 2008 Faber report and the policy itself. And that, together with the 3 paragraphs of analysis, I think compels the conclusion that the case must be vacated for a proper environmental justice analysis. Thank you.
Thank you, counsel.
Good morning. John Holgerson for the town of West Bridgewater. The definition of a Zone 2 aquifer is found in 310 CMR, Section 2202. And a Zone 2 is an area of the aquifer which contributes water to a well under the most severe pumping and recharge conditions. The importance of that is that the Zone 2 aquifer in West Bridgewater, the northern boundary part of it, runs for 0.7 of a mile along the Salisbury Plain River. The proposed plant would essentially take away 1.9 million gallons a day of treated effluent from the AWRF in Brockton. And the question becomes, if in fact that occurs, what are the environmental impacts on the Zone 2 aquifer? Not necessarily on a volumetric capacity or water supply, but on the Zone 2 aquifer, the geology of that body. What is not presented in the petition, either the initial petition that was filed on July 12th, 2007 by the company, are a description, or is a description, of the environmental impacts on that aquifer, on that Zone 2 aquifer. Even if this court adopts the definition of a petition set forth in the company's brief, which the town does not subscribe to, obviously, even under that circumstance, you will not find the environmental impacts accurately and completely described. And the company's definition would essentially render nugatory the board's requirement by virtue of its own handbook to conduct public commentaries on, quote, full petitions.
And what's the practical consequence? Because all of this relates to wastewater effluent, which the town will not, which the city will not sell them. So you're basically complaining that they did not adequately consider the consequences of using wastewater effluent when they're not being allowed to use wastewater effluent.
That's the political position between the city of Brockton and the company at the moment. But as we all know, political positions often change, and they change frequently and sometimes quickly. The point being that the petition that Brockton Power put forward specifically utilizes the AWRF effluent, specifically utilizes the AWRF effluent and thereby denies the Salisbury Plain River of it. The petition should set forth the environmental impacts on the Zone 2 aquifer, regardless of whether or not ultimately down the line the city of Brockton maintains its present position not to sell the AWRF effluent to the Brockton Power. That's the bottom line. What does the petition do? Does the petition meet the statutory standard as far as accurately and completely describing the environmental impacts of the denial of that AWRF effluent on the Zone 2 aquifer?
Now, the board did consider the impact in terms of the well water. Are you saying that there is a different analysis that must be done with regard to the aquifer as opposed to the aquifer which feeds
The best way I can explain it in very layman terms, for my benefit, not so much for the courts, is if the court envisions the aquifer as a sponge and the 4 wells that are in that aquifer as straws in the sponge, the bottom of those straws absorb the moisture and water that's right there and force the sponge or the aquifer to seek out replenishment. So the well capacity is one aspect of this. But what will the aquifer, how will the aquifer expand? Where will it find the additional water resources to replenish itself once the 1.9 million gallons daily is denied?
Where's that 1.9 million gallons going after it goes
to cool the towers, essentially.
Where is it going?
It's going nowhere after that. It goes from the way it would be set up, as I understand it, the evidence at the hearing was that the effluent would be taken from the AWRF and the plant would use it essentially to cool the towers.
But does it
All
evaporate?
It would all evaporate, yes.
Your time is up. Thank you.
Thank you.
May it please the court. My name is Gregor McGregor. With Nathaniel Stevens, my associate, we represent the City of Brockton as special counsel. As you sense already, this matter has been fully litigated, but with key rulings preliminary to the adjudicatory hearing and during the hearing about evidence that was excluded. Hence, multiple parties, public and private, supported by many amici, ask you to vacate the decision of the citing board and remand. My issue is air. I'll make 3 points with my limited time. You already know from our opening brief, pages 8 and 9, there are hundreds of residences within 1,000 or 2,000 feet and schools and other community centers. You already know from our opening brief, pages 9 and 10, that this plant represents potential emission of more than millions of tons of pollutants, greenhouse gas type, as well as the so-called criteria pollutants, 6 of them regulated by the Clean Air Act, all of the province of EPA. The legal beef here is that the citing board, instead of carrying out its statutory mandate to do a determination of air quality and health impacts for being complete and accurate, relied on simply the company's assurances it would meet the National Ambient Air Quality Standards, NAAQS, promulgated by EPA. The reason that's a legal error, that is, it's not a statutory determination of completeness and accuracy of air quality and health impacts in the application before the board, is that the NAAQS is promulgated by EPA. They are nationwide. They are not implemented directly on plants, but rather through the states and their sets of regulations. They do not reflect, they're not a product of individualized EPA determination on the sufficiency of anything about this plant. When and if this plant applies for federal permits, it could be years, and when and if EPA issues permits under review or under a delegated program to DEP, the federal permits are granted, then we'll know about emissions. But the statute says the first role of the board is to do a determination of the completeness and accuracy. And for reasons stated in our brief at length, we say that is a default under the statute. Secondly,
I don't get this. I mean, EPA are experts in this particular area. I know there's a dispute with regard to the American Farm Bureau decision, but the board considered that and said, we won't even use the 15. We're going to use the lowest estimate that anybody at EPA suggests, which is 12 with regard to the fine particulates, and that's ultimately what EPA chose. And they said that even with the emissions here, we're going to be well below 12. So what more are you asking them to do? You're asking them to retain a whole set of air scientists to seek to replicate what EPA has been battling for the last 10 years about the impact of fine particulates?
Justice Gantz, no. We're asking that they have their experts submit for the record, for review, in the adjudicatory proceeding with cross-examination, their assessment of the impacts, and the board to do its independent judgment of the sufficiency, the
But Mr.
completeness and
McGregor-
accuracy.
No, please finish.
We are not asking that EPA, and EPA does not do a plant-specific determination to substitute for what the statute gives the board to do. They simply, in the original proceeding and in the PCF, the project change filing also challenged here, relied on the assumption, they actually say they assume the plant will meet federal standards. There is no individualized determination. There is no specific findings of what the emissions will be. It's just a quotation of what the company says they will be. There's merely mention of what the brief of the city and the other parties say. There's no discussion of the evidence they submitted.
But have we ever said that the board has to conduct an inquiry as thorough as you are suggesting they must undertake? Isn't the board, they're just coming up with a roadmap as to what has to happen in the future for the hundreds and perhaps thousands of permits that have to be issued in order for this project to go online. And the DEP or the EPA, aren't they the final word? And why don't we let them make the ultimate decision in this case? It seems to me that you're asking to have two hearings, two full adjudicatory hearings on the question of air pollution.
Yes, Your Honor. The court, in the context of what findings a board is supposed to make when confronted with adjudicatory evidence that is fully contested with live witnesses, is supposed to make individualized subsidiary findings. We ask that you hold this board to the Chicopee case and the MIT case, and I have those with me if you want to discuss them in detail, but the point is that it is not enough, according to Justice Hennessy and Chief Justice Marshall, to merely quote.
Those are utility cases where, I mean, they're in a different posture than what Justice Spina is talking about, aren't they?
No, they're under the predecessor statutes.
Well, but
this
the
agency
MIT case
administers.
was not an EFSB case.
That's right. They are Chicopee versus MCAD and the New York Central Railroad versus DPU and MIT versus DPU, which was about power plants, and what the agency is supposed to do when faced with contested evidence with witnesses whose credibility needs to be judged with subsidiary findings in the decision. You'll look in vain in the first decision and in the PCF decision for subsidiary findings.
Your time is up.
Please vacate the decision and remand to the citing board to meet the previously announced requirements of this court.
Thank you, counsel.
Good morning, Your Honors, and may it please the court. I would like to spend the majority of my time this morning talking about the environmental justice issue, and if I have any remaining time, I'd like to say just a few brief words on the city's appeal of the PCF decision. The environmental justice policy serves important public purposes, but it is not mandated by the board statute or by any other statute.
Well, it is a policy of the Commonwealth,
It is, Your Honor.
and I understand it has all the language about it's not, it doesn't give a right of judicial review, et cetera, et cetera. But insofar as 69J and a fourth incorporates that, or instructs the board that it needs to comply with and do things consistent with the environmental policies of the Commonwealth, doesn't it come in through that door?
Well, I have two responses to that, Your Honor. First, the residents can't pick and choose among the provisions of the policy and say that some provisions are enforceable but others are not. So my position is that the policy includes the disclaimer, which reflects that the executive office voluntarily adopted this policy, but with the caveat that it was for internal management purposes only.
Every policy is just for, I mean, the very nature of it being called a policy would mean that it's not enforceable. It becomes enforceable only because the legislature said that it was going to require the board to incorporate policies. So it seems the disclaimer doesn't matter.
Well, I think it does matter, Your Honor, but Your Honor is correct that even the general rule is that internal agency guidelines of this sort, with or without a disclaimer, do not give rights that are enforceable in judicial proceedings. And the disclaimer is making express what this court has already held. But my second response to the policies provision in the statute is that policies is not a term of art that means internal agency policies.
But you're suggesting that all we need to do is pay lip service to this policy, and that the very brief attention and information that was supplied in response to what the policy calls for was adequate. Was it really adequate to handle something so complicated as what the citizens here, the citizens group, is asking the court to review?
I believe it was adequate, Your Honor. If the court reaches the issue, the board's interpretation of the policy should be entitled to substantial deference. Now, the residents say that no deference should be afforded because this policy was promulgated at the cabinet level and binds many other agencies. The residents cite no case, and I'm aware of none, that says that the board can interpret an internal agency guidance under a de novo standard of review. And the fact that it
In the court,
binds-
did you mean to say the court? The court can interpret?
I'm sorry, the court, yes, Your Honor. And the fact that the policy binds many other agencies within the executive office only reinforces that this policy should be read to be for internal management purposes only.
So is it your position then that a particular agency could decline to do the procedural aspects as well as the substantive aspects? I mean, suppose there wasn't this involvement. There'd be no consequence whatsoever?
It wouldn't give rise to a judicial remedy, Your Honor. It would, however,
Consequence be?
the consequence would be that the executive office would have the power to direct the agencies within its authority to comply with the
And
policy.
if it decided not to do that, that would be that?
With respect to a judicial remedy, I would say yes, Your Honor, but Chapter 21A, Section 4, gives the Secretary express power to implement programs that it jointly agrees to with the agency and to coordinate and implement programs that the Secretary, and to coordinate and improve programs that involve two or more agency within the executive office's jurisdiction.
That sounds like a green light for dealing with blighted neighborhoods. Just invite a power company to come in and put an electrical generating plant. We solve the problem.
Well, again, Your Honor, the Secretary does have the authority to require compliance with this policy, and it was a policy that the Secretary adopted voluntarily. It could be amended or revoked
Yeah,
at
but
will.
it's on the books.
Well, then what does 69, what does that clause or paragraph
so-
mean in the statute then?
So going back to the second part of my answer, Your Honor, the policies is not a term of art that means internal agency policies. It is a general word with broader meaning that can encompass things such as legislative policies and regulatory policies. For example, on page 94 of the board's decision, the board considers policies to encompass DEP and EPA regulatory standards governing air emissions, as well as DEP and EPA regulations governing wastewater discharges and work in wetlands areas.
Fair enough, but that doesn't mean it's limited to those, does
It is not, but it doesn't render the word policies meaningless to give effect to the disclaimer here. There are also legislative policies, for example, in the board's recent footprint decision, which is cited in one of the amicus briefs, the board considered a project's consistency with a climate plan that the executive office was required to develop and implement under the 2008 Global Warming Solution Act.
Let's assume you don't prevail in persuading us that this is not a policy within 69 1/4. Did they comply with the policy?
They did, Your Honor, and again, the board's interpretation should be given deference because by statute, the secretary of the executive office is the chairman of the board, and his designee voted to approve this final decision, and that's in the board's enabling statute, Chapter 164, Section 69H. And the board's interpretation is reasonable. The policy gives a long list of services. They are all procedural in nature except for the one provision that requires an enhanced analysis under MEPA if certain conditions are met. The secretary himself found that those conditions were not met and that an enhanced analysis is not required. And so the board reasonably determined that the policy did not change the substantive analysis in this case, and nobody disputes the board's determination that the procedural aspects of the policy were met. Very briefly, with respect to the city's appeal of the PCF decision, I just wanted to point out that the relevant statutory provision, which is the second to last paragraph of Section 69 1/4, says, quote, if the board determines that the standards set forth above, namely the standards by which the board evaluates petitions, have not been met, it shall either reject the petition or approve the petition subject to stated conditions. Then the very next sentence says, it, quote, in the event of rejection or conditional approval, then the 180-day deadline applies. So the juxtaposition of the two sentences indicate that the 180-day time frame only applies where the statutory requirements have not been met and the board either rejects the petition or approves it with conditions that are intended to bring the project into compliance. But the board here found that the company's petition did meet the statutory requirements, and Brockton Power did not seek to have any of the conditions lifted out of the decision.
Thank you,
Thank you.
counsel.
Good morning, Mr. Chief Justice. May it please the court. David Rosemswijk, appearing on behalf of Brockton Power in this matter. I'd like to start by joining with the argument of Assistant Attorney General Shin on all issues she argued, particularly on the issue of the EJ policy. We do believe that the disclaimer has legal effect and should act as a bar to any claim that's brought to interpret or challenge the requirements of the EJ policy itself. That is the precedent of the federal courts in both the First, Ninth, and D.C. circuits under the Sir Contra case, for example, where the federal EJ policy, the executive order for EJ, has been determined not to be subject to challenge in the federal courts.
Right.
What do you
but the
say on
federal-
that score to, I think it's Allen, I'm not sure the name.
Yes.
But am I right about that? Judge
You are,
Sarris's
Your Honor.
decision? So, at least as I, some brief reading, but as I read it, because the agency had looked at EJ issues through the NEPA policy process, she felt it was appropriate to review judicially, despite the fact that the federal executive order says the same thing as ours in terms of judicial review. So I guess my question is, isn't that analogous to the language in 69J and a fourth?
It is not, Your Honor, because under the Allen Court's decision, it's only where an agency as a matter of discretion elects as a matter of discretion to undertake an EJ analysis, that EJ analysis becomes subject to review, let's say, under the Administrative Procedure Act, to determine whether those findings it makes are arbitrary and capricious. But that case makes clear, as do the other federal court cases, that the requirements itself of the EJ policy are not subject to judicial review, either by the federal courts and, we would say by analogy, the state courts.
So what was the nature of the information and the depth of the information that Brockton Power supplied so that the board could make this determination as to whether or not principles of equal justice had been satisfied?
It was considerable, Your Honor, and even if the disclaimer provision does not apply, the standard under Section 69J1/4 is a flexible and permissive one, determination of general consistency.
Could you give me just a summary of how considerable that was, the nature of the information that was provided?
Yes, Your Honor. The company presented evidence that the project would comply with the National Ambient Air Quality Standards, and those are standards that apply throughout the region, both to EJ populations and to non-EJ populations. And under the findings that the Siting Board made and the evidence provided by the company, it established that its project would meet the National Ambient Air Quality Standards, which says not only that air impacts will be minimized, but the health impacts associated with the facility would be minimized in such a manner that when the NACs are set, they're set at a level that are protective of all populations, the most sensitive portions of the populations, to ensure that there are no adverse health effects. So when the Siting Board found consistency under J1/4, Section 69J1/4, they did so basically on three bases. They did so based on the procedural steps that the company implemented with regard to notice, with regard to translation, with regard to outreach, which again was considerable. They did so on the basis of consistency with the Secretary Bowles' determination under the MEPA policy that enhanced outreach was required, but the enhanced air analysis was not triggered because the project itself did not trigger a 250 ton per year threshold.
What about the siting itself? How is that addressed? The fact that a plant of this nature was sited in a particular minority, a particular neighborhood with minority concentration.
Again, Your Honor, that was decided in accordance with the various findings the Siting Board made with regard to the air impacts and the siting.
But it's just with respect to air impact, not with respect to the fact that most of these plants seem to be sited in low-income neighborhoods or minority-impacted neighborhoods.
Well, again, on this particular facility, it's not going to be sited in an EJ neighborhood. It will have emissions that go into EJ neighborhoods and non-EJ neighborhoods, but it is located outside of an
It's in an industrial park.
It's in an industrial park that is zoned where power plants are an allowed use. So it is not in an EJ area per se, although its emissions are ubiquitous and they would fall both on.
Could I just ask, when one looks at EJ policy, at the EJ policy, does it go to siting or more the consequences of the operation of the power plant in that area? In other words, air quality or, let's say, it could be noise if it was something else. Is that right? Or does it actually physical location as well?
I would say, Your Honor, it could be construed to cover both.
Okay.
And the Siting Board's findings on all of the impacts of the facility deal with minimization of impacts across the Commonwealth. I was just using the air impacts as an example because those are the impacts that the appellants seem to be most concerned about. And the Siting Board made all the findings under its statute that this facility would be considered with the EJ policy and consistent with its own statute, and that all of the impacts that are relevant for this facility have been shown to be minimized.
Could you tell me now, Mr. McGregor tells us that the board relied on the company's assurances that it would meet the standards. Is that so?
Well, it found the company's testimony to be credible and worthy of considerable weight, but there was 20 days of evidentiary hearings and over 800 exhibits.
Did they say that we assume that the company will meet the standards?
No, Your Honor, clearly not. They weighed the evidence of both sides. They found the company's evidence to be most credible in determining that the air impacts, for example, would be minimized. They looked at the models the company would use, and they were EPA-approved models. They looked at the data that the company was using for modeling purposes and found that to be representative. They looked at the modeling assumptions the company used and found those to be appropriate and consistent with DEP standards. And they also took comfort in knowing that DEP looks at these issues, will set the emissions level, and that it needs to act consistent with DEP under the town of Andover, and ultimately it would be DEP that would be making a determination as to what would be the
Which would
permissive.
be some years down the road, right?
It's in fact happened already, but
Yes.
it can be,
Well, of
it
course,
can
this
be
was
several years down the road. In this instance, it has already occurred, and it occurred in a
Of
way
course,
that
this
is.
decision was 2009, so it's already some years down the road.
Yes, and it turns out that they were consistent, but it's a proper recognition of the dual roles of the siting board, who makes the findings at the first instance, at the front end of the permitting process, and other agencies such as DEP that make findings at the back end. And here it was done in a consistent manner. I would like to touch upon, if I could, one of the arguments presented by the town of West Bridgewater regarding the effects on the aquifer. When that issue was raised, the company conducted an analysis. Its analysis was unrebutted. It made a whole host of very conservative modeling assumptions, like there wouldn't be rain or any precipitation within a year. It looked at how the pumping of the aquifer occurs and what the effects would be, and they found, with the company's analysis, no plausible way there would be any adverse effect on the wells or the aquifer. And it was
That's assuming that AWRF is used, is that right?
that was on the assumption AWRF would be used, which would lead to somewhat of a diminution of flow in the Salisbury Plain River. But the town's water supply does not come from the Salisbury Plain River, it comes from the aquifer. So all of those modeling assumptions were looked at, and the unrebutted evidence from the company's expert was that there was no possibility of any adverse effect on the aquifer. At most, under the most extraordinary level of assumptions, there would be less than a 2-inch effect on the aquifer if there was no rain over a 1-year period, and the aquifer would continue to operate appropriately.
Now, counsel, your time is up on this case.
Yes, Your Honor, that's correct. And I will move on to our separate appeal in the 11405 docket concerning our appeal of the PCF decision. May it please the court again, David Rosenzweig appearing on behalf of Brockton Power in its separate appeal of the board's PCF decision. Our appeal is limited to the single issue of whether the company's request to use municipal water for its approved generating facility was appropriately denied by the board. We contend that the board's decision should be vacated for 2 reasons. First, the board's decision is not based on a proper evaluation of the evidentiary record because it fails to consider substantial evidence presented by the company concerning the minimization of water impacts. And second, the board's action is inconsistent with and intrudes upon DEP's comprehensive authority under the Water Management Act and its related regulations. I'll start with the factual issue, and as time allows, I will get to the legal issue. Both the board's decision and its briefs before the court emphasize incorrectly that the company presented no evidence regarding the potential water impacts on the Silver Lake, not Salisbury Plain River, Silver Lake, with regard to its proposal. This is simply incorrect and should be remanded. As the court is well aware, the board's obligation in making factual findings is to consider the full extent of the record, including those facts that might fairly detract from its conclusions. While admittedly most of the company's evidence on water impacts concerned what it believed was going to occur, that is, it would be supplied with water from the Aquaria plant, it absolutely presented evidence concerning the minimization of water impacts and the negligible impacts on Silver Lake. As an example, in order to gauge the potential impacts on Silver Lake, the company's expert, Mr. Barton, presented an analysis that given the size of Silver Lake, it would take approximately 17 million gallons of water of withdrawal to affect the level of Silver Lake by 1 inch. And under the most extreme conditions, that is during the summer, during a drought condition, when perhaps the plant was using its maximum amount of water, if you conservatively assume that maximum use would occur for 90 days, Brockton Power's water use would amount to 189 million gallons, meaning it would result in, at most, and in fact it would be less, than an 11-inch effect on Silver Lake. And given the normal fluctuations in the lake, which amount to several feet, that less than a foot, 11-inch effect on the lake under the most extreme conditions would have no adverse effect on the environment, no adverse effect on the habitat.
Isn't the board allowed to consider the fact that the greatest amount of water loss would be in the summer, because it takes more water to cool down the generators in the summer, and that also is the time of the lowest water level in Silver Lake and concern that it may affect the mussel population, which would affect the overall cleanliness of the entire Silver Lake Basin?
The board has that authority, Your Honor, and the analysis that Mr. Barton presented considered those facts under the most extreme conditions and found that the impacts would be minimal. In fact, there were studies in the record presented by and commented on by the company that mussel population occurs not at the top surface of Silver Lake, but predominantly at lower levels, like at 17 feet below the surface. So there was evidence in the record from the company that demonstrated that its potential impacts on Silver Lake would be de minimis.
And you're saying there was no contrary evidence by anybody else?
There was contrary evidence, yes.
Well, then why are they bound, why was the board bound to accept yours?
At a minimum, they're bound to consider it. Our analysis, our facts aren't refuted or even referenced in the citing board's order. And as a project proponent...
Sound like Mr. McGregor about the city.
Well, I would say in Mr. McGregor's case, their evidence was considered, and there was not a claim that there was no evidence by the other side. And I would say there's a heightened requirement when you're a project proponent, where you're spending millions of dollars and your rights are being adjudicated, that your testimony is considered and looked at before there's a determination that you have not met your burden of proof, which was the case here. The citing board was duty-bound to consider both our evidence and the evidence of other parties, and to give it whatever weight it deemed appropriate, but not to say it didn't exist. The company also presented significant evidence regarding how it was acting to minimize its amount of water use. It had engaged in significant conservation efforts and a redesign of the facility to reduce the amount of water we would use annually by about 87 million gallons a year, 200,000 gallons a day, less than the facility that they approved in the underlying proceeding. And the company put forth a very generous mitigation proposal of $100,000 a year that would give to the city to mitigate any impacts. None of these considerations were considered or referenced in the board's order.
Did Brockton Power litigate that particular issue? Were they asking for a decision on that particular issue, or did they take the position that DEP had already made that decision and the board was foreclosed from considering it?
We did present that evidence, and we claimed that we showed that our impacts would be minimal, both on the Aquaria plant, if we use Aquaria water, or water from Silver Lake. We also made the claim that the board's determination was inconsistent with DEP's authority, in that they failed to understand that when DEP permits and with registrations was overseeing the city's water supply, that it was doing so with minimization of environmental impacts as an integral consideration, and that under the town of Andover, the board was bound to act in a manner that was cooperative and consistent with DEP in looking at the water impacts. And if DEP found a certain level of water withdrawal would be permissible and consistent with its permit limits, that the board should have been acting in a consistent manner with DEP's actions, but here they failed to do so.
But the only evidence you have the DEP carefully considered this is the ACO itself. You have no other documents to indicate that the DEP came to that determination based on any analysis. You just have the ACO numbers, right?
We have more than the ACO. There's something called the Comprehensive Water Management Plan that DEP was implementing in conjunction with the city, that on a year-to-year basis required the city to make reporting and to show what it was doing to minimize water impacts. And it was considerable, particularly through conservation, where the city had reduced its water consumption from sources like Silver Lake from 17 million gallons when the ACO was first implemented to less than 10 million gallons per day since that has occurred.
Right, but the gist of your argument, I mean, you're adding 10%. You're using 10% of the water that's used by the entire city, and your argument would have to be that the 10% does not place a substantial burden on an already burdened lake basin. Are you saying that DEP said that there's no harm done to the Silver Lake as long as it's below 11.3?
The standard, Your Honor, is not no harm. It's a minimum of harm.
Okay, so a minimum of harm.
Yes, and we would say that the DEP's management, aggressive management of conservation, aggressive management through the Comprehensive Water Management Plan, and the setting of permit limits, and in fact the setting of a safe yield, which includes environmental protection, all are directed to minimizing environmental impacts. And Brockton Power's withdrawal would be consistent with those limits. So yes, Your Honor.
Thank you, counsel. Your time is up.
Good morning again, Your Honors. I know I have a very limited amount of time, so I would like to focus on the arguments that are raised in the reply brief. None of the record citations that are provided on pages 14 to 16 of the brief supports Brockton Power's argument that it presented evidence regarding the impacts on Silver Lake. Those parts of the record simply describe the Teal study and the GZA study. They don't draw any conclusions from them, and they don't undermine them. And in fact, some of those citations confirm that the company did not present evidence regarding Silver Lake. For example, on pages 2107 to 08 of the joint appendix, Brockton Power's expert was asked how reducing volume in Silver Lake would impact wildlife habitats, and he responded, quote, "I really don't think I have enough personal knowledge to give a complete answer to that question. There have been other things written about seasonal levels and how those changes may affect the mussel population, but I really don't have a complete command of lake conditions to be able to give you an accurate answer," end quote. Likewise, on pages 2207 and 08 of the joint appendix, the Brockton Power's expert confirms that the company's position is that all of the project's water would come from aquaria, which he then says is, quote, "Why we did not feel within the bounds of the project change filing, it was necessary for us to do a detailed environmental analysis of many aspects of the city's historical system," end quote. And when Dr. Barton was testifying about how the water levels would be affected by the volumes of withdrawals, he was just testifying more generally as to the trends of the water in Silver Lake after aquaria was added to the system. He did not say that the residents' concerns to the ecosystems were overstated. He did not say anything about the ecosystems at all because he simply did not do that analysis. So it's clear even from the citations that the company provides that the company put all of its eggs in the aquaria basket. There was no evidence presented regarding the actual effect of adding Brockton Power as a water customer, which would essentially tap out the city's historical system and draw some additional water from aquaria, which the city has made clear that it intends to use in reserve during drought situations. And before the company is allowed to eat up such a huge chunk of supply, over 10% of the city's current demand, potentially undoing 2 decades of work by the DEP and the city, it must present actual evidence regarding the environmental impacts, and it has not done so, and so I'd ask that the board's decision be affirmed.
Thank you, Counsel.
Thank you.
I'll follow up on what Ms. Shin just argued. Brockton Power is, in essence, complaining that the siting board made a conclusion based on an interpretation and an evaluation of critical information having to do with the unprecedented scale of the use of the potable water that would occur if they were allowed to have this project change. And also, Brockton Power is complaining about the conclusions that the siting board reached based on their evaluation and judgment of the relative weight of the evidence that they put in the record as against what the board found was far more compelling, and that's the testimony of the residence expert, Alex Manfield, the Teal study, and the GZA report. And this is a classic example of the kind of decision that is well within the broad discretion of the board, and it is the board's prerogative, having heard 20 days of testimony, to consider the evidence and to make a decision. Now, Brockton Power says they didn't actually consider the evidence. I suggest to the court that they did, and if you look at the project change filing decision, you will see, in contrast to the 3 lonely paragraphs on environmental justice, a 14-page analysis of the water supply issues here that ends up with the board correctly stating that the company did not provide an analysis of the different impacts on the Silver Lake system that would result from the water consumption with the proposed use of potable water for cooling water towers as compared with the original proposal with the water consumption without the project. In other words, to be clear, they didn't analyze what the use of this project with potable water would add to the system if the project wasn't there at all.
The burden.
The burden. And instead, they did rely on the threshold argument that they felt they could persuade the board that all of the potable water they would be using would come from the contractual Aquarius supply. When the board did not accept that argument, they were then left without a fallback analysis that they needed to carry their burden of proof. And for that reason, the board was correct in reaching the conclusion that the project change filing with respect to the water supply should not be allowed.
If I could impose upon you and my colleagues to go back to the EJ issue.
Yes.
Just for one question. You seem to be suggesting that EJ policies means that they should be considering sites outside of EJ areas, but the statute makes pretty clear that with regard to site selection, the only determination is whether or not it is an accurate description of their process. And in town of Andover, we said they have no burden to be considering alternative sites. Are you asking us to undo Andover?
I am not asking you to undo Andover, and we accept that we do not get an analysis of other sites under that first subparagraph of 69J1/4. But that rule and the holding of Town of Andover does not change the equally applicable rule that we are entitled to a determination of consistency with the policies of the Commonwealth, and where one of those policies requires consideration of other locations. Through that route, we do get that analysis. But I am not asking for any change in the rule
So
of
you're
Town
saying
of
they
Andover.
need to consider alternative sites, but under the policy provision, not under the site selection provision?
Under the site selection provision, in the old days, before the Restructuring Act, the proponent would have had to say, not only, here is the site where we wish to build and all its pros and cons, but here are the details of the other sites, and the board would have a crack at actually looking at whether they had chosen the right site. Now all they have to do is describe their site selection process accurately. We leave that alone. But it is still the case that under the separate third subparagraph of 69J1/4, the board must make a determination of consistency with the environmental justice policy. And what I am suggesting, Justice Gantz, is that the plain terms of that policy call for the kind of disparate impact analysis that does require Brockton Power and the board to look both at the location they chose and, in a comparative sense, how that compares, not with other sites where they might build, but with other places in the Commonwealth where burdens of this sort are imposed on low-income communities of color with a high percentage of foreign-born and non-native English speakers. That's the analysis we get under the consistency prong because of the plain terms of the policy, and that is in no way inconsistent with the rule that, with respect to the site selection prong, all they have to do is describe their selection process.
Counsel, your time is up. Thank you very much. And
you.
thank all of the lawyers for helping us with the time.
Thank
Thank you.